We are going to talk about, the topic is today is called Who You Tweeted What? Legal Consequences of Social Media. So we're going to talk about the legal end of this social media revolution that we're experiencing right now. Before we get started, just by a show of hands to see where the audience is, how many of you have a LinkedIn profile? Okay, everybody. Okay. How about Facebook? How many people have a Facebook profile? How many of you are using your Facebook profile for business? Okay, a couple. Who has a Twitter account? Okay. Okay. And how many bloggers do we have? Okay.
I'm curious how many people have two Facebook accounts, one for personal, one for business. Okay. So that's a growing trend.
Okay. How many of you are with businesses that have employees? Okay, a couple. Okay, so we got everything kind of represented here. So what we're going to do is we're going to talk a little bit about some of the underpinnings, the legal underpinnings that have been the same no matter what the communication is, and talking about how those things. Greg's going to talk a little bit about trademark and copyright and how those issues arise in this space with social media and blogs and whatnot. And then we're going to just kind of teach by example on some of the topics, the hot topics that are out there. So we'll talk a little bit about social media policies, why they matter, what should be in them. We will talk a little bit about the kind of the real hot issue in terms of liability, which is defamation. We'll talk a little bit about that. And we'll also talk about how some other laws interact in some unique areas of the law that affect social media, and we're going to do it largely by telling some stories about some of the cases that are out there. It's a developing area of the law. A year ago there wasn't the volume of cases that we have even now, and it's with business law, with real estate, with employment law, there's an established body of law that's been around. Things get added from time to time, but this is kind of the new frontier in terms of how everybody's feeling out this social media stuff in terms of some of the lawsuits that are coming up. We'll also talk about some enforcement things and some particular problems that, even though the traditional rules apply to social media communications, the problem's been trying to apply the typical tools of enforcement to maybe stop a defamatory tweet or post. So why don't we start, Greg, why don't you take over and talk a little bit about the trademark and copyright as it relates to using some of what you're doing online.
And I think the biggest issue, and I did an awful lot of IP clearance work at IBM, so when you saw the actors on the television commercials, we secured the talent. When you saw the various ads, the catalogs, I was one of the lawyers that wrote that little fine print at the bottom that went through and just made sure everything was quote unquote legal. It used to be back, not in the good old days, but back in the day, that if you violated someone's trademark or copyright, that the evidence trail was pretty small. If you printed up some t-shirts and were selling them on Times Square, your inventory of t-shirts were gone pretty quick. If you made a pamphlet, what have you, you exhaust your inventory very quickly. What we see happening now with the internet and social media is not only are you broadcasting potential infringing activity to a much wider audience, potentially to an audience that's policing these sorts of things. There are companies like Getty Images, there's the Record Industry of America, numerous film companies that have all sorts of monitoring technologies to surf the web to find where their content's being infringed upon, including on places like Facebook, YouTube, those sorts of things. And it used to be that your infringing activity didn't garner the attention of anyone. Nowadays, not only is it attention grabbing, but it's creating an evidentiary issue where once you put it up there, you can't take it back. So it's really difficult that once you potentially do something that's problematic to go back and even fix it. You can correct it, but it doesn't necessarily undo the infringing activity and absolve you of any liability. So one of the things that we are helping particularly small and medium businesses with is the clearance process, the way to take the sort of notion of willful infringement or true bad acts, dirty hands, all that sort of thing, off the business process that's going into this. So particularly when we're doing activities on Facebook and that sort of thing on a commercial basis, we tend to say that all the same rules apply, all the rules around trademarks, all the rules around copyrighted content. If you're pushing music through your website, that needs to be cleared, which is a pretty easy process. Most of the things we need to do to make your commercial presence clean and non-problematic are pretty straightforward, but it's skipping those steps that's creating some liability for companies. And they're getting bills from Getty Images, as an example, for $1,800, $5,000, that sort of thing, which they're stuck paying because they did it. So that's I guess just part of the landscape. And so when Jeff is out doing all his fabulous Facebook marketing, those sorts of things, we're careful that small businesses simply don't follow suit without thinking about some of the legal ramifications. So I tend to take a much more cautious approach because I've been on both sides of those cease and desist letters. I've sent a ton of them out, and I've worked with clients in responding to them, and they are really no fun. And we'll talk about some good examples about that as we go. But I guess the bottom line is all the rules apply, and I think they're magnified.
Yeah.
I don't think they go away, and I think for a commercial operation, I think the problems create liability that you don't necessarily expect.
I think one of the biggest issues when it comes to, okay, what do I have to be worried about legally when in the social media age is online reputation management. That's no different from websites, blogs, whatever. You have to be monitoring what folks are saying about you. And there's a few cases that defamation cases in the Twitterverse are starting to become more and more common. You guys probably already know the rock singer Courtney Love. She's had more than one run-in with the law with her tweets. She had one where she said something allegedly defamatory about a fashion designer and ended up settling that one for $430,000. Now I was just reading today that there's another one that's she accused some of the lawyers for her husband's estate of taking bribes through a tweet. So now that one is possibly headed to trial. So
the question, if Marshall was here, he would certainly advocate, well, she's free to express her opinion. No one believes what she's saying is factual. And so it's a huge balancing. And part of the issue in balancing, even if it is free speech, the problem when you go to litigate these claims is you're getting into six-figure litigation pretty quickly on any sort of defamation or IP issue.
Yeah, what Greg said, you can't take back a tweet, and this stuff happens in real time. I mean, this isn't the old days where someone is putting together some kind of marketing flyer and is going to go through a number of hands and review it and vet it before it ever gets published to the world. This is someone who's got a smartphone blasting out at rapid
maybe a couple cocktails, maybe
exactly.
Maybe
yeah, fueled with a little liquid courage, and all of a sudden you're saying stuff that is ticking somebody off, and then pretty soon you've got some legal issues. So that's
in a commercial sense. Though, we're always free to do things like comparative advertise. You've probably seen the commercials that compare the legroom between a Nissan and a Toyota. I mean, those sorts of things are always acceptable. It's kind of when you get into this more pointed where you're disrupting business, potentially affecting the business's reputation and making true misstatements and false, whether they be allegations or otherwise unfounded
right.
statements.
Right.
But the worst part about this, there was a recent incident where the lawyer for a business instructed the business to go delete all that stuff after there was a legal issue that popped up. Go delete it all. And what happened is you really can't delete it. The court found out. They not only sanctioned the lawyer, but they assessed penalties against the business. And again, 6 figures, big expenses come out of this real quickly, which is this is new territory.
Yeah, I mean the rule in terms of the monitoring your reputation. Obviously, you want to be setting up Google alerts for your name and your business's name and things like that to be able to monitor what's being said about you and your business online. The tricky part comes in terms of enforcement, because like I said, the most common issue that comes up through the use of social media is the defamation argument. So you said something that was false about somebody, it hurt their reputation, they want to sue. The typical remedy, or the first step in going after somebody for a defamatory statement, is typically a cease and desist letter moving towards some kind of injunction. or to take to rescind the offending material. Like you said, it's hard to rescind something that was posted on Twitter or Facebook. Facebook itself, Google, are loath to take. They're very pro First Amendment free speech. They're loath to take something down because somebody requests it for some legal reason.
And they have federal immunity, so there's legislation that gives these. They're treated as venues or intermediaries, and just because it's on their website creates no liability. There's some safe harbors related to actions they should take out of due diligence, but like the Yahoos of the world, the Googles, all those, they have to take no action to help you and clean up your mess. They can just sit there and continue to operate, collecting millions of dollars.
And there's a couple of cases that are included in the packet that kind of go to this point of how trying to use the traditional methods of shutting down a defamatory comment or pursuing the claim doesn't always work in the blogosphere or the Twitterverse. One of them was a website. Has anybody ever visited a website called thinkgeek.com? No one? Okay.
Kind of like The Onion?
It's a blog site, and every April Fool's Day they run a fake product ad. That's just kind of the joke they do, right? And it's something outlandish and crazy. Like a couple years ago, they did one for canned unicorn meat. And it was canned unicorn meat with extra sparkles. Now, it was funny. They had a little recipe for something or other. The unicorn supposedly pooped marshmallows and all that. So it was really done well. It was funny. But at the very end of it, they say, unicorn, the new other white meat. And the National Pork Board didn't like that. And so they engaged their lawyers, which is this firm has an office here. There was a different office, not the one here, to send the cease and desist letter, which is the typical first step in policing an infringing comment. So this was dealing with trademark, because the Pork Board holds a trademark for the other white meat. Okay. So the law firm sends a 12-page cease and desist letter,
which is on the long side.
Yeah, a little bit wordy. Sends it to the proprietors of this blog. They did not take down the ad. They had another blog post captioned, "The best cease and desist letter we've ever received."
I think the best cease and desist letter ever.
Yes, yeah. So so now the law firm and the Pork Board now get lampooned in a blog post over their objection to what was clearly a parody on April Fools. I know from some folks in the meat industry, this thing. I mean, you probably maybe have seen it. It hit the Pioneer Press. It hit the AP. It hit the news. A lot of the Star Tribune. It was on the Ag Wire, and a lot of people in the industry were like, "Why the heck did the Pork Board waste thousands of dollars sending this stupid letter? What was obviously a joke."
And I would say tens of thousands for that letter.
Yeah.
Given the firm's reputation.
Yeah.
It's probably very, very expensive.
So that would be the typical response to a trademark of infringing action like that, but it backfired on them online.
And the letter went online. So I actually use the letter occasionally to grab interesting language because it's so well written.
Mm-hmm.
And so I've had cease and desist letters get posted when we've done this. So I always double check with the client like 5 times. You really want to take this action, because what can happen is it can escalate, and they can try to make you look foolish, particularly on the copyright side of things. So think twice before you send nasty emails or correspondence, because they can come back to bite you.
And then along the same vein, we had another case involving alleged trademark infringement, and this was a good example of someone who has a lot of friends who are active online. There was a gentleman named Daniel Rothamel. His kind of tagline is he's the real estate zebra, and his website has a whole bunch of zebra markings and designs and stuff like that. And he was sued by a group called the Lonas Group out of Washington State, and they did designing websites for real estate professionals and things like that, and they claimed a trademark in using the zebra stripes in the real estate sphere, and they had a registered mark. The problem is the real estate zebra was very well known to a lot of folks who are active on Twitter. Within hours of this news breaking that he had been sued, someone had gone ahead and set up the real estate, what do they call it? The ZebraDefenseFund.com. So you had all his colleagues, his friends on Twitter rally to his defense, and kept, and just, I mean, some of the stuff was vicious. Some of the stuff that they were shooting back at the plaintiff in this lawsuit. I mean, they usually say frivolous lawsuit or asinine. I mean, people were just, you know, again, it's that real-time communication, right? People are fueled with emotions, they're firing it. So again, would that be the typical response to a trademark infringement? Would be to bring an action for an injunction? Absolutely. Could that probably should have been thought through a little bit and thought about the consequences of what was going to happen for someone who had a large following online when that news broke? Probably. So there's two examples of old rules, but the old tools don't necessarily work. A lot of folks will, you say, okay, well, what the heck is the solution then? A lot of folks will say that the best way to handle a comment like an infringing remark or a negative remark would be you go to your web person, your SEO person, and you get enough positive stuff put out there about your business or about you, so that Google starts picking up that and starts driving the negative stuff onto page 2 and 3 or 4 where people aren't looking. That sometimes might smolder the fire out faster than bringing the lawyer in, because you might be more apt to be pouring gasoline on the situation.
But now on the flip side, for this audience, where I think a lot of you might be the recipient of a cease and desist letter, I sometimes just think that's not the end of the world. One, I think it's almost a sign that you're actually gaining some market traction, and so I appreciate getting those. And so if you do get one, I usually don't recommend just ignoring them. I usually just send off a quick letter denying the claims, saying the issue's closed, and wish them a good day. So for a new startup business, I think it's sometimes the best sign that you're on your way.
And the other way a business can handle it, and a lot of bigger companies do this. Comcast, I know, Sears, Best Buy, they have a Twitter account and they're monitoring comments made about their business. Someone may have a customer service complaint and they issue it via Twitter, and within, you scroll down a few tweets and pretty soon they're thanking the company for how quickly they responded and helped them out. So some businesses look at this as a customer service opportunity. If something is said, someone's complaining about bad service or something else, they're proactive. They jump in and try to correct the situation, and a lot of times it does that. You end up with a positive comment for the effort. So a lot of different ways to think about it. There's no cookie cutter. This is the way to do it. You gotta know the players involved, and you gotta think about how this is going to play out, in the blogosphere, in the Twitterverse, in terms of how this is going to be received when you bring the lawyer in right away. Marshall, our partner, has said it's amazing how many of my letters end up online. When he starts firing off cease and desist letters.
All the jobs social media has created, just in monitoring negative comments for companies.
Exactly.
Well, I think the other issue for this room, and Doug, if I can use you as an example, so if I've got a new venture, queue up, what have you, and one thing that we're seeing more and more of are sort of anonymous attacks. So people are posting things on Merchant Circle or Ripoff Report or some of these other venues, and it is very difficult to make an anonymous post. And there's ways for us to unmask those anonymous posts. We can file it results in a series of lawsuits and subpoenas to go unmask first from like Merchant Circle, then you have to unmask the IP address from Qwest or Comcast. So anonymity is kind of a question mark. There's ways you can do things anonymously. You can go to the library. You can do all sorts of things to try to harass a company. But my sort of point on this is to do this sort of unmasking exercise. We just had a client who, low six-figure sort of revenue, being attacked viciously all over the internet, and it's really impacting their business. So they're losing. They've said they've lost half of their business as a result of this negative attack. And we had to kind of spec out for them what it would cost to unmask these posts, and it's $20,000 sort of initially to file. We have to file a lawsuit in Mountain View, California first, We have to issue all these subpoenas, and so it became really very expensive versus just dealing with it like Jeff described, dealing with this through optimization, maybe through some metadata on your own website, which is the underlying hidden text of your website. Taking some self-help action, like writing to some of these websites and say, I'm the owner of this company, this is clearly defamatory. The one thing that really helps small businesses, a lot of these websites have terms and conditions that forbid posting of information that's defamatory, pornographic, all sorts of things. And if you write them and say, this post clearly violates your terms and conditions, a lot of times they'll take it down. And you can do that without hiring a lawyer and get some pretty cheap self-help.
I have a question back on your original example of the Courtney Love tweet. Would it have been possible for the company to write a cease and desist order and her to say, I'm sorry, I won't ever do it again, and it would have been over? Or
yeah, that would have been the cheap way.
But she would not cease and desist? Would that be why it would have gone further then?
Yeah, big egos equal big legal bills and big settlements usually. Yeah, there's ways to nip these things.
There's usually a attendant claim besides the apology. Or a rescission of the offending remark. There's usually also a claim for damages of what lost business. You know, this was a fashion designer, and someone who was wearing her clothes said some not nice things about her, and that affected. The claim was that it affected her business quickly and directly and significantly. Hence the six-figure settlement.
And if you look at the First Amendment issue, if you go all the way back, if you've seen the movie about Larry Flint and his adult magazines, you know, that First Amendment issue was resolved in favor of free speech, but only after millions of dollars of legal fees and all the way through the Supreme Court. So we've got these fabulous rights and these enforcement and sort of both, on offense and defense remedies available to businesses. It's just the cost of them can be problematic for a new startup.
Are the products like Reputation Defender?
Those are great. Yeah.
That's a good tool. It would save you 20 grand in legal fees.
Yeah, that's like optimization. You can try some of those. What they're really doing is they're trying to optimize for you. I'd say a lot of those, don't you think, Jeff? I mean, I think like Reputation is more an SEO. I mean, but there are also services out there that will go through and do the sort of monitoring watch service and try to protect your brand equity for pretty low cost. You can, in addition to Google, you can subscribe to watch services to watch your brands and get a quarterly report that says here's what's up, kind of thing.
One more question, that is, what about some of us in this room who don't have a lot of connections and precious few followers and friends on our social media accounts? Are they watching us too? Are we liable to get the same kind of order as Courtney Love did with that sentence, or is it only because of the impact hers had that they care?
I would say there are companies like, I use Getty Images because they're notorious for it. We were talking about them coincidentally at another meeting today, but they go after everyone. But the Courtney Love example, I mean, if you know there's a pot of gold at the end of the rainbow sort of thing, you certainly go after deep pockets.
Well, the Getty Images is unique because it's a thing that you literally used of theirs and didn't pay for,
right?
As opposed to a defamation kind of thing, which may not have any impact if I don't have any followers.
Yeah, well, the one of the things the important point on the photographs, Creative Commons license or a stock photo account with someplace like Shutterstock.com or something like that. You want to have that if you're putting images on a blog or on your website, because obviously, to take a copy, there's a copyright in any photograph or any picture that's taken that belongs to whoever took the picture, and so you have to get permission. You have to clear these things if you're going to use a copyrighted image like that. So that, like when I blog, I have a Shutterstock account that I pull stock photos from and paste, or they're my own photos. I do some real estate stuff. I did one on hunting land leases. I found a picture my wife took of a pheasant in our backyard, and looked remote enough that I said, honey, can I use this? Yeah, okay, cool. All right, pop it up there. I got permission to use it. I didn't take the picture. Those kinds of things.
And there is this concept of fair use. Fair use is where you can use other third-party content, music, pictures, for some very limited. It's a defense. It's not a right. Under very limited circumstances. And I would say, even if you're blogging, but the underlying point of your blog is to somehow create interest and capture attention related to your business, that will never constitute fair use. Fair use is things like news reporting, face-to-face education purposes, parody, but even in Jeff's case, where he's actually educating through the blog, writing articles, but really at the end of the day, the analysis will say, is he actually trying to gain some marketing for his law practice? Yes. So fair use doesn't count. So in most cases, be careful about the idea of fair use.
So only if it's altruistic, then it's fair use?
Yeah, and it's not a bright line test either. It's you almost need to go have it vetted through the federal court system. But the examples are, again, news, criticism, education. You have to be careful about education. So things that like Globe and some of these online educators are doing, you have to be careful. It's really meant to be this sort of classroom. So what Jeff's distributing here, potentially fair use for education, I would say arguably not. One hand, arguably yes, the other hand. And so it's always a kind of subjective analysis. But we usually give you an opinion on fair use, but in most cases, if you're a commercial business, we always say clear it or get permissions. You had a question?
Yeah, and I don't know which one you direct this to, but if I take a really nice picture I've taken and post it on Facebook, have I given up my rights to copyright that picture if someone else is to use that?
No.
Have they done that?
Facebook doesn't take your copyright, but they grab some rights for themselves. So if it's something that you're very concerned about, you want to be sure you review the then current rules of Facebook that apply to you, but you're granting Facebook a license to it for all intents and purposes, and you're potentially opening yourself up to more copyright infringement. So if it's a cool picture, someone can right-click, download it, and go put it on the cover of their book, and you might not ever know. So that's so if you've got something like that, what a lot of companies do is they watermark it, they put some sort of tag in it. It's amazing the way that you can protect photos and music and little bits and bytes these days.
One really quick question on the subject. If I take a picture of, say, 3 people on the lobby, and in the background, by accident, there's a person with a Coca-Cola logo on their shirt, they somehow get in my photo, I post that on Facebook, can I be sued by Coca-Cola? Is this kind of where we're always seeing the blurred image on people in these commercials or whatever?
And there's some famous cases on this. There was the movie Seven, if you ever saw that movie with, I think, Brad Pitt and Morgan Freeman. There was a bunch of artwork and things in the background, and the question was, did they need to be cleared, or was it de minimis, just sort of scenes, passing by sort of scenes. So you do have to be careful if you're taking something that's got another company's logo, and if it can be interpreted that you're somehow using that image and it has the impact of bolstering your brand, then Coke will likely come after you. So that's why you see it blurred out. And it's become ridiculous what we have to blur out these days. So you own the copyright to the photo you've just taken. The people in the image potentially have some rights of publicity, and whether they had an expectation of privacy or not is a question. So you got privacy, publicity, copyright, all intersecting on that.
Follow-up question, is it different if it's professional, or would it be different? Is there a difference, a distinction between professional and personal? Meaning, of course, I know I'm a creator of content, but if I just happen to take a photo of my friends and post that on my personal Facebook account, is there a distinction in the law between personal and professional?
You know, it goes almost to the heart of damages as well. So you're looking at things. One of the benefits of being a trademark owner is if someone infringes your trademark rights, you can go after the culprit for their profits and your lost profits. So in that example, I would say even if you were found to be infringing, you might be obligated to take it down, but what are the damages? You weren't selling anything. No one was, well, potentially you may have tarnished their brand depending on what the photo was. But you know, the damages assessment there kind of results in no liability.
Thank you.
I have a question too. I apologize for being late, so you may have already covered this, but what about YouTube? Does YouTube own anything you put up there, or do you retain ownership?
You own it, and we're getting into, you know, there's so many chunks of legislation. There's a thing called the Digital Millennium Copyright Act, which is a chunk of legislation that came out in the 90s. So what happens is you own the content. So you'll probably notice, and Jeff's probably run across this as much as I have, but if you share links of YouTube videos, one week, the next week you might see that they're gone. So what's happened is someone has sent a cease and desist letter or takedown request to YouTube and said, that's violating my copyright or my trademark, take it down. And as long as YouTube complies with that, they're free of liability, and they just have to take it down. They generally take things down pretty aggressively, but you retain your.
Yeah, YouTube is much more aggressive than Google or Facebook, and much more willing to take things down. If someone posts, a clip from a TV show and puts it up there, that'll come down. It might be there for a day, and someone complains, and that clip isn't there the next day.
The great part of copyright law in the U.S. is that to transfer ownership of it, you need some sort of written agreement. However, you might be giving some implied rights, and you're creating some difficulty in enforcing your rights if you're just kind of posting it, because you assume it's going to get right-clicked and used and copied. But yeah, ownership does not shift. You're still the copyright owner.
Well, in some cases, there's this agreement thingy, kind of, sort of, and it says right-click click this if you agree that this is a legal copy.
Yep.
Oops.
Yep. So they're pushing back. So what you're agreeing to there, which if you read the fine print, probably says something that if YouTube is sued and held liable for damages because of the content that you posted on YouTube, they're going to hold you responsible, and you're agreeing to hold them harmless and pay their attorney's fees and all that sort of thing. So that's what that says. It's the same sort of language. So it's not really a new issue. I don't know if any of you have ever ordered personalized checks with like Disney characters or sports characters, that sort of thing. It's the same concepts that have been around for quite a while, that when you post stuff or provide stuff to a printer, you're making a representation that you've got legal rights to do that, and then you're going to hold everyone in the chain of creating that event or that product harmless, which can be scary. I mean, you're agreeing to pay attorney's fees, all that sort of thing, which, I mean, the likelihood is you don't have the money to pay YouTube's attorney's fees, but that's what the contract says.
The other big issue, defamation of the reputation management is probably the biggest issue. The second biggest issue in dealing with this pertains more to businesses that have employees, but it can apply across the board to, let's say, a homeowners association has a Facebook group, or an organization like ours has a LinkedIn group and there's commentary on it, and that comes down to social media policies. Policies of who can be using company equipment, computers to be during the workday to be doing this, to be on these sites, or what kind of access employees are going to have to sites, and then of course what they're saying about the company. We've got a couple of instances actually from here in Minnesota that kind of highlight the importance of having social media policies. One of them happened a few months back. If any of you are football fans or Viking fans, do you remember some stories about Bernard Berrien and his Twitter account? Got into it with a state rep, John Kriesel, after a game. Kriesel kind of, just made a snarky comment about how Berrien's over here claiming he's always open. You want to read some good humor, go look at his Twitter account. And Berrien shot back and told him, one part of the tweet was, sit down and shut up. Well, he's a double amputee war veteran from the Gulf War, and when people informed Berrien of this, he didn't back down. The next day, I should mention, Kriesel's one of the sponsors of the stadium legislation in the House. So the next day, at least I think the coach and I think the owner might have got involved, because Berrien was leaving a message for Kriesel apologizing. And they made it clear in the Monday morning press conference that Bernard had apologized. I don't think Bernard played another snap after that. He was released about the week or so after. And Frazier alluded to in his press conference that they do have a policy about what the members of the team are doing on social media, and and they talk about that, and apparently Bernard strayed from the policy. The other one actually is a case that went up through the all the way up to the Minnesota Court of Appeals. Also got a lot of publicity here in Minnesota, called Tatro versus the University of Minnesota. This was the young lady who was a mortuary science student at the University of Minnesota and was taking a cadaver course and was, Facebooking about the course and had named the cadaver Bernie and was talking about what she was doing with Bernie. And then she broke up with, her boyfriend broke up with her or something, and she made some comment about her status update. Says she's looking forward to Monday's embalming therapy as well as a rumored opportunity to aspirate. Give me room, lots of aggression to be taken out with a trocar. I don't know mortuary science, but apparently the trocar is a very sharp object that could, in the right circumstance, could be used to cause some pretty serious harm to somebody, like maybe an ex-boyfriend that just dumped her. And so he was a little concerned about that. I think he might have been the one that actually complained to the university. But anyway, she was given an F in the class and suspended. And she appealed this, and she made the usual free speech, off campus at the time. She was just venting, all these kinds of things. The U of M has in its course handbook some guidelines about what students can and can't be doing via Facebook and other social media sites, and this fell into that realm. And the district court found for the university. It went up to the Court of Appeals, and the Court of Appeals upheld that. I didn't ever see that the Supreme Court took it. So when the Supreme Court doesn't take it, they mean for the Court of Appeals decision to stand. And so in that case, what saved the day for the U was the existence of this policy in their course handbook that said, you couldn't do this. There was another question that talked about it was in the mortuary science course guide that said conversational language of cadaver dissection outside the laboratory should be respectful and discreet. Blogging about the anatomy lab or the cadaver dissection is not allowable. And then there was another side note that the court didn't really get into about whether or not posting on Facebook equated to blogging, because they had other policies that they could rely on to save the day on that one. So two situations of showing why having something in place, and even if it's if it's your employees or if you've got a blog site and if you ever look on like the Star Tribune, now they have the comment section, right? And there's guidelines there. Don't say anything profane or racist or defamatory, and they have those guidelines there, and they reserve the right to to strike a comment if it's if it violates their policies. So if you're working with a company, you should have a social media policy. I'll have Greg talk about that in a minute. And at a minimum, if you're doing blogging, you should have something out there. If you get a lot of comments, you should, if you're worried about that, you can put some guidelines in there as to what type of comments are not allowed. Or you can also, like for my own personal blog and for our firm's blog, all comments have to be, they're not posted immediately, they have to be approved. So we can wipe out, there's a lot of spam comments that get posted on blog sites, so we can dump those before anybody ever sees them. So why don't you talk about, because you've actually written some social media policies.
Right, and largely in Minnesota and most states, employees are at will, so you don't need a policy to necessarily terminate an employee, but you can see in situations where you're expelling a student, if you want to immunize yourself against retaliatory lawsuits, if you've got employment contracts that have specific terms, these policies will help regulate day-to-day activity and give some basis to your hiring and termination decisions. So these are usually things that talk about, don't post things, don't expose trade secrets of the company, don't make statements derogatory to clients, all the things that can come back and affect a business. So these are 3 to 10 page, documents that talk about, all of these little topics. Along those lines, we always think it's a great idea that if you don't have one and you do have employees, that you have a In addition to social media, things like copyright policies. So your business says to its independent contractors, and I put this in just about every contract that a business pushes out, whether it's for an employee or a PR firm that they might be hiring, a web designer that they might be hiring, but it says something that you will not infringe another party's intellectual property rights and copyrights, that sort of thing. And what that policy will do for you, it's much cheaper than insurance, but if you ever do get sued for copyright infringement for something that someone else did, you can kind of pull this policy out and say that is not the policy of this company, and it kind of takes the willful sting out of copyright infringement and puts you either into a no damages situation or a very small, incident of potential liability. So these policies, I think, are, along with things like errors and omissions insurance, things like that, these are just a great, number of kind of a reverse picket fence, but a way to keep liability from coming and dragging away from your company. The other thing, and you may want to just touch on this, that if you're blogging or posting content as a business, if you do it under the framework of a limited liability company, that will also insulate some of your personal liability for some of these actions as well. And then disclaim things to no end. On our blog, we say we are not providing legal advice. The opinions are those who are making those posts. All those sorts of little things are all what we call safe harbors, and just create layers and layers and layers of defenses and insulation. They're not particularly rocket science in nature, so they're not costly. You can generally even grab a decent stab at one off the internet, and Jeff and I look at these all the time, and sometimes it just takes us 10 minutes just to make sure it's Minnesota appropriate or whatever the case may be. So well worth the time.
There are limits, though, to how much you can enforce with the social media policy. Obviously, you get into First Amendment issues, and if those apply. But also, there's some narrow laws that can sometimes preempt a otherwise enforceable social media policy. And there was a case it was a complaint filed that was brought by the National Labor Relations Board a year ago against a company called American Medical Systems of Connecticut, I think they were called. Yeah, American Medical Response of Connecticut, Inc. And this was somebody that went on their Facebook page and made some comment to the effect of, I didn't know that they hired 17s as supervisors around here. 17 was code in that business for psychiatric patient. Okay, and she was terminated for that because that violated the company's social media policy. The problem for the company was that this was a union position, and what she came back with was what the complaint is that under the National Labor Relations Act, under Section 7, they had the right to complain about management. And so what the issue was does that extend to posting on Facebook complaints about management? And that one, without being decided, that one actually, there was a settlement reached, and I think she was brought back or whatever. But again, a very narrow applicable law that preempted the otherwise enforceable social media policy. So they aren't a panacea in every instance.
And there's examples. Our law firm has a blacklist, so certain personnel don't have access to things like Facebook from company equipment. I've done some work for banks and those sorts of institutions, and they really put in technological safeguards, which is becoming very cost effective to do, to limit the sort of things that not only employees, but if you're an independent contractor doing, say, programming for a bank or doing website development for a bank, they make you use their computing, one of their laptops on their network, and they build in all those controls, so at least they can control what you're doing when you're working on their stuff on their dime on the clock. But what you do off hours, I mean, that's a whole different issue.
You pull your phone out of your pocket,
Right.
out the computer, and
Yep. And so our firm's policy actually says don't do that if you're working. Go do it on a break or what have you. But it's become almost impossible. Just like we were talking in class today, Can we control file sharing of music? Probably not. Can we control everyone's use of social media? Probably not. I mean, we can just take the best steps as a business owner that we possibly can, and limit as much exposure without being unreasonable. Some of our social media policies that we're asked to write, I think, seem a bit overreaching and unreasonable, too restrictive. I think you my personal opinion is you want your employees to feel as if they're respected and trusted to be able to go act reasonably on the internet, but it's a balancing.
The last issue we should talk about in terms of the legal issues here pertains to blogging specifically. The Federal Trade Commission got involved a while back and put together some guidelines for internet advertising, and it applies to bloggers. If there's blogging promoting a product and you're being paid to promote the product, the FTC guidelines say you have to disclose that. So, Doug, for example, if I did a blog post, if you paid me $100 and I did a blog post on how great your QUp app is,
Jeff O'Brien is a paid
I would
sponsor
have to
of QUp.
disclose that by the way, I'm being paid to write this.
But it's not a new rule. That's the same rule that's been like on when you see the guy from Jeopardy advertising insurance. You see the little disclaimer at the bottom.
They've just now extended it over and applied it to blogs.
Do you have to do that in the body of the blog, or at the post addendum, or
I think just it has to show up somewhere.
In the really fine print.
If you go too fine with the fine print, then everyone will say that you've tried to confuse the consumer. So depending what your industry is, you always want to do your notices and disclaimers in a manner that sort of a common denominator will understand and be able to find. If you make it too difficult or too fine a print, then they'll come back and say it's a deceptive trade
so
practice.
I may be paid. I really do like it.
Yeah, exactly.
But create a forum where people can say both good and bad things. I think people saying I didn't like the taste of Diet Pepsi, I love the taste of Diet Pepsi. I mean, it creates a buzz. I wouldn't be afraid of opening up, an active dialogue about your products. And a lot of companies will actually respond. Yeah, we fixed that on our latest release.
I had a thing like that on Twitter. I was sitting on a Sunday night talking about a software, an app, and I wrote something, I really liked it, but here's something I didn't like. A few minutes later, I get a reply saying, well, explain what you're talking about. I explained what I was talking about. I got another tweet back, and I had another question. So I looked the guy up, and he was one of the app developers for the company, sitting there watching for me to use the name of that product.
I think everyone nowadays assumes that the good and the bad kind of flow with, creating a social media presence. I can think of one individual off the top of my head that I know will if he can't sleep, will write reviews about all the things that he's used throughout the course of that day and post them up, and in a state of exhaustion. And there's nothing you can really do to defend against that. I mean, to a certain extent, it is what it is. I mean, like Jeff says, you can build technological controls and limit what gets posted, but
Comcast monitors the social media very heavily. Someone posted that their office phone system was down, and Comcast got a hold of them right away, and someone was there very, very quickly.
oh, that's very cool.
Yeah, they're one of the best ones locally that do a quick response. 'Cause see, it's gotten to the point now where if people have an issue, they tag the Comcast Cares account and try to let them know and go through Twitter to have the issue resolved, because they're known for responding to issues via Twitter.
And I take a less aggressive approach than Jeff does on a lot of internet activities. One, because my days are filled up with a variety of different things that don't give me the flexibility to necessarily devote to monitoring online activity. So I'm often stuck on the paper side of my practice, as opposed to where Jeff maybe is able to focus more on the online side of the practice. And so you kind of make that choice. So if you're going in the deep end of making an exposure on the internet, be prepared to be, I think the standard is becoming even as responsive as Comcast, if not more.
Yeah, I'm probably a little bit more active because I have to keep my Facebook and Twitter accounts open during the day, because it's gotten the reputation of how much I use it. People actually contact me clients or potential clients through Facebook and Twitter, so I have to keep them accessible. So when it comes in, last week one of our associates was in my office, and I seriously got an employment law question from a friend through Facebook. He goes, "Seriously, Facebook?" I said, "Take them wherever they come."
So who works for who?
Huh?
Right. Yeah.
Jeff, in regards to blogging, I'm kind of new to blogging. Is it proper etiquette or form to have, at the bottom of your any references you've made, or giving credit, or on any articles you would write?
Yeah, giving credit. What I like to do is, if I'm like, say for example, I'm writing a blog post about a story that was in, say, the Star Tribune. Okay, I'll go first to the Star Tribune, and because I don't want to spend my blog post reciting the facts of the story, I'll go to the Star Tribune, copy the link, and then do a hyperlink from my blog post to that story. I'll give you an example. I did one. There was a story in the Star Tribune about how 41% of Twin Cities homeowners were underwater. Now, the gist of my blog post was not to comment on that part of the story. It was to use as a jumping off point for something else, which was how to deal with neighbor disputes and the fact that everybody's stuck living next to each other, and these are going to be more problems. And so, and then it was a bunch of humorous stories around the country about neighbor disputes. Okay, but I had linked to the article just because the focus was not the statistics in that story. It was just I got this story, and now I'm going to talk about this. And then you have, so I always link whatever I'm talking about through the blog post, and I might mention it's from the Star Tribune, or it was from whatever. I do that. I also do another series. They're real estate news ones, and it'll be like a kind of a daily rehash of some of the headlines, and I'll have the link, and I'll say via whatever the site was. So it's just all I'm doing is just kind of being an aggregator for that.
So
I always give credit.
Jeff is describing the right way to do it. If you copy and paste the article in total, Star Tribune will come after you.
Yeah.
They want you to come through their link so you can see their advertisers, so they can give their advertisers their click credits, that sort of thing. But don't forget, I know one thing you want to think about, and I'll use Warren and Doug again as examples, that if you're doing a blog, or you have a forum or a bulletin board or whatever you want to call it on your website, I always throw in a little thing that says, anything that you submit on this forum, we own it. You then have a copyrighted work, and you can take advantage of, someone says, wouldn't it be great if your products did X, Y, and Z? And you say, that's fabulous. We're going to go get a patent. We're going to trademark. We're going to do all that. So when you make those submissions, keep in mind that when you're making them, you're probably giving rights away. But then as the owner of the forum, you want to make sure that you're trying to protect that as well. You want to say that this blog is the copyrighted property of QUp LLC, what have you, reproduction's not authorized. If it becomes really valuable in a resource, chock full of useful technical tips or that sort of thing, you could even file a copyright for it for $45 or $35. Just little things like that. But if you put that language in there and then you use something to your company's advantage, it's fair game. It's fair game anyways, but it just kind of helps, yeah.
I always like, if I'm taking something from somebody, sometimes I'll ask them for permission and vice versa. I've had contact people saying, hey, can we reprint your blog post on our blog? So they ask me permission, and of course I grant it, and they put it up, and things like that. So if you have a question about it, just contact the person who is created the material and ask for permission to.
And almost every one of these sites has the terms of use that'll have the contact information and the rules about linking and all that sort of thing. The days of the internet of being this glorious, cross-connected spider of resources is sort of done now. It's just become a series of cross-contracts, is what it's really become.
Syndication.
Yep.
Other questions?
How is the new proposed piracy and intellectual property legislation going to affect the social media environment?
I haven't studied a whole lot yet. I know that amongst those who blog on political and policy issues, there's a real concern over whether or not their continued livelihood after, if that law were to be passed?
Yeah. I think it's still to be figured out. I mean, again, it's tightening down what was meant to be a free flow of information, which is sort of the polar opposite of what the internet is meant to be. But the Copyright Act hasn't changed really materially since the mid-'70s. Little changes here and there in the late '80s and '90s, but really where we're at with content and legislation, we're worlds apart. So we're dealing with antiquated laws, with data that's moving faster than we can keep up with. I mean, we don't know what's going to be around next year, 2 years, 3 years. We know the laws will be the same and probably not apply very well.
Other questions?
Do you see those laws changing then? I guess that begs to be asked.
You know, there was a great chunk of legislation that kind of helped pay performers in the music space. The problem is these legislation, they get proposed during a session of Congress that Congress expires, and then it's got to start from scratch again. And I'm still frustrated I can't buy some of the light bulbs that I like to buy that the light bulb legislation passed. It's, you know, this sort of, you know, vying for priority. So I think with the economy in the state it is, we're not going to see a lot of legislative move on some of these copyright issues.
In terms of the proposed law that Curtis was talking about, we won't know what's going to happen. It'll be a political football all year, and then the first Wednesday of November we'll find out what's going to happen to it.
Okay. Yeah, sure.
After the day after, we'll know. Whoever ends up running the show, we'll find out what's going to happen to it.
Are there any things happening internationally that will affect our laws or internet use, blogging, et cetera?
Well, the standards are often more consistent internationally now. It was just the late '80s that the U.S. became a member of the World Intellectual Property Organization Treaty. So there's consistent treatment of some of the copyright and trademark laws worldwide. The biggest problem we have now are countries that are not members to some of the controlled or some of the more standard internet registries like GoDaddy or Network Solutions. So if they're not bound by the same rules that the rest of the world play by, Australia is a good example. It's very difficult to press your rights in Australia. You have to start a suit in Australia, you have to hire a lawyer in Australia. So what we'd like to see is a more standardized set of enforcement tools to apply across the internet, period. We're not quite there. We're getting closer, but we're not quite there yet. I mean, we're seeing all the things out of Southeast Asia. I'm sure if you've ever filed a trademark, you've probably gotten something that talks about registering your mark in Hong Kong, all sorts of funky things. So there's still gaps.
My son travels to the Far East a lot. He's usually there for a month or so at a time. And he said you would be shocked at how many, just walking down the street, looking in the storefronts and so on over there, that a movie just came out in the theater here, and 2 weeks later, the pirated copy is already for sale over there for $2.
I always joke with friends that are traveling worldwide, bring me back some nice counterfeit goods. Countries, I don't mean to throw any country under the bus, but countries like India enforce their intellectual property laws much differently than we do. And there's almost a sense of encouragement to compete with patent rights that have been solidified in the U.S. or other countries that are part of the international treaties. But there's a whole series of international treaties, and we're still not members to all of them. So as an example, we have some musicians that still have not been paid for some international royalties because we're not a member to some of the treaties yet. But it's moving slowly, though.
Yeah, Thailand, Malaysia, Taiwan are places that he's mentioned where these are there immediately.
Well, and if you are, and I maybe mentioned this to Warren, talking about some of your thoughts about expanding products worldwide, keep in mind that if you obtain rights in the U.S., you may not be getting rights that extend worldwide. So things like trademarks and patents have to be applied for. There's some unified ways to do it, but they have to be applied for on a country-by-country or region-by-region basis. Otherwise, what you're doing in the U.S. I guarantee you that once you make that filing, that there's someone else in the world that's saying, that's a great idea. I will copy that. So we're always very careful with clients if they've got a great business plan, that they're very well organized before they start launching things in the public records database, because once that happens, all bets are off. And it's kind of a race. And some countries are a first to file versus a first to use, which means if you don't file in that country, you're out of luck.
Anything else?
My last little tidbit, if you're doing a promotion, a giveaway, contest, something, and you're using social media to do it, all the same state-by-state laws apply. So if you're running that, giving away an iPod, that sort of thing, and you're using Facebook as the launch pad for that, keep in mind that you have to comply with all 50 states if the winner can come from any one of those states.
We actually did the last time we did this, part of a panel on social media legal issues. We were in the planning session and we get handed the draft marketing materials, and it talks about winning a free iPad too. And Greg looks around, he's like, "Where are the contest rules? Where are the rules?" So
Rules? What rules?
Greg gave him the rules for the contest to keep them legal.
But the Attorney General will come down, well, probably a lot of Attorney Generals will come down hard, and you could be, $10,000 times however many states you might be violating. So it's kind of strict liability if you don't disclose. You have to, odds of winning, rules, where to write, all that sort of good stuff. Keep in mind that you're essentially in the realm of each state. I always say in your websites, if they come back to your websites, I always try to identify where your company is located. I always say QUp is located in Minnesota, and its servers and systems are located in Minnesota, to try to create some jurisdictional hook for you here to keep you out of other states. But just little things like that to be thoughtful of. And if you're successful, then that's where the risks come in, because someone will. And sore losers of contests, by the way, are a horrible thing. They're whistleblowers to the AG's office. Yeah.
If you put a disclosure on your contest that this is eligible only to residents of Minnesota over the age of 21, that would hold up?
Yeah, that would hold up. Just make sure you don't then do a drawing and give it away to someone in Iowa. There's ways. I mean, we worked with one client where there was a web registration, and so they just, for the address field, if you tried to select, you could only select a state that it was applicable for. So there are ways to do it that way too, but yeah.
Okay, well, Greg and I'll be around a little bit to answer questions. What's our next meeting date? February what? 8th?
Well, you'll be giving away an iPod.
So February 8th is our next meeting back in this room, and speaker to be determined. So keep your eyes on the email. If you're new to AM, want to get on the email list, see our webmaster back there and give me your email address so you can include it on the email blast. So thank you all for coming.